Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Today, we are live getting ready for the Donna Adelson hearing that's going to happen in the next 15 minutes. I wanted to kind of touch base with you real quick before we enter into this motion hearing. Right now, in Tallahassee, Florida, Donna Adelson attorneys have filed yet another motion arguing divorce papers between her daughter Wendy and Dan Markle should not be included in the evidence of her trial. In the filings, her lawyer said over a 560-page divorce, and I thought mine was long, has nothing to do with Donna Adelson or any alleged motivation to conspire to red room her son-in-law Dan Markle. The attorney then suggests that the state is using the divorce between Dee and Markle to support the false narrative that the divorce was a bitter custody battle. Dan Markle filed for divorce from Wendy Adelson in September of 2012. Let's see. Court documents show Wendy moved the kids while Markle was traveling, but her later attempts to legally relocate the children were denied about a year after the divorce was granted. The motion filed Wednesday argues the divorce papers are irrelevant to Donna Adelson's upcoming trial this summer. Quote, an objective review of the court files reveals that the dissolution of the marriage between two well-educated professionals involving minor children and assets. Neither party alleged abuse or neglect, such as one that has been have a base to seek majority time sharing. A hearing is scheduled to keep Donna Adelson from seeing the grandchildren unsupervised. The motion comes a week after judge denied Donna Adelson request for a bond, citing her attempt to board a one-way flight out of the country to the wonderful country of Vietnam. So that is what we're waiting for on the Donna Adelson trial. That is set to begin in any minute. We are waiting for it to begin. I am going to get her up and going. Come on. Oh, that's fine. All right. So we got Miss Adelson up and going. What else do we have? Something's hitting in the courts. Let me see. Okay, that's good. I just got, see, everywhere I broadcast to Facebook, Twitter, Twitch, or whatever that is, Instagram or whatever, and then YouTube. And unfortunately, I have to go in and change settings on every single one of those every time I go live. Hey, Miss C. Morales. Good afternoon, Miss Libby. Thank you guys for joining. We greatly appreciate you. We really, really do. We are waiting for this wonderful woman who has gained quite a bit of weight. And I am trying to finish up a bite of pizza. I can barely eat one piece. So, Granny Gotti, we got 6 minutes. Ooh, that carbonated. Okay. I think the only big thing that happened today in the Karen Reed trial was that the prosecution's motion to basically have the communications between Miss Reed and her attorneys on January the 29th through February the 2nd was denied. Yay! Auntie Bev literally cut off the attorneys and just like, I've had enough. I've decided we ain't doing it. And we are sitting here on pins and needles, waiting, anticipation for the documents to come down. And as the gavel drops, we do have one document that did post this morning. Let me go ahead and give a quick look over and potentially read until the Adelson case does come into trial. So we'll go ahead and start on them. The memorandum of law in opposition to the Commonwealth's motion in limine to preclude the defendant from raising third-party culprit defense. This has been a little bit crazy. They keep wanting to push this issue, the prosecution. So here's the defense's side. Now comes the defendant, Karen Reed. Miss Reed respectfully requests that this judge deny the Commonwealth's motion in limine to preclude the defense from raising a third-party culprit defense. The third-party culprit evidence Miss Reed intends to introduce at trial meets the relevant admissibility standards. We're going to scroll down. I'm sorry. I'm still getting over this upper respiratory. Number one, Mr. Brian Albert did not have a good reputation among his fellow police officers. He was known to bully and sometimes who has a history of sucker punching fellow officers, particularly when he's drinking. He has been investigated by the Boston PD Internal Affairs Division for his violent conduct in that regard. Albert is a trained boxer, and several of his fellow officers were afraid of him. Okay, the prosecution said there was no internal investigation on Brian Albert. So I'm going to say, show us the proof. We need the proof. Where's the proof? Brian Albert was present at the scene of John O'Keefe's death on January 29, 22. John O'Keefe's lifeless body was found on the Albert's front lawn, just feet from his front door and his door of his garage. Brian Albert admits to having been home at the relevant time, and the evidence, including computer forensic data, overwhelmingly established that John O'Keefe entered Brian Albert's home. I think we might be reaching a little bit on the overwhelmingly establishes that fact. It has not been actually established at all. That would fit the level that they're trying to rise. Brian Albert was drinking heavily throughout the day and night. Just FYI, drinking began heavily at the after funeral party for a fallen soldier or fallen police officer. Brian Albert spent the day and night with Brian Higgins. So Brian Albert and Higgins were together that entire day and through the evening. In the weeks leading up to John O'Keefe's death, Brian Higgins had demonstrated a romantic interest in Miss Reed, although Brian Higgins would have you say Miss Reed had the interest in him. Mr. O'Keefe's girlfriend, but He had been rebuffed, essentially ghosted. And on this night, Higgins was confronted with O'Keefe and Miss Reed together, clearly happy. So that night, he could see that O'Keefe and Miss Reed were in good spirits together and happy at that moment. Higgins' words and deeds revealed significant aggravation. Well, there's some video that popped up where it appears he's very aggravated and they're having to calm him down. Brian Higgins and Brian Albert's home. Brian Higgins was in the Brian Albert's home when John O'Keefe entered after a period of time. Brian Higgins left the Alberts residence but maintained contact with Brian Alberts. There were suspicious and unexpected phone calls between the two of them at 2:27 a.m. on January 29, 22, not long after O'Keefe was mortally attacked. The O'Keefes have injuries and wounds on his arm from an animal or dog attack. Brian Albert had a large German Shepherd at the location on the night of the attack. The German Shepherd, which undisputedly had a history of violent dog and human attacks in the past. This aggressive and violent German Shepherd was, according to Brian Albert, not good with strangers. None of this evidence was investigated by the police in charge of this case. Trooper Proctor, who's been fired on with a dishonorable discharge. In fact, the evidence shows that was by design. Ex-Trooper Proctor was asked in the text exchange whether homeowner Brian Albert would catch grief as a result of having a dead body of a police officer in his front yard. Michael Proctor's response demonstrated his intent to protect a fellow police officer, saying, "Nope, the homeowner is a Boston cop too." Verify his intent to give a pass on Brian Albert. There is also a conclusion of guilt evidence implicating Brian Albert despite a massive police presence on the front lawn. Just feet from his bedroom window, Brian Albert never came out of the house to speak or interact with the first responders. It is worth noting that Brian Albert was at all times a first responder himself, yet he chose to ignore his duty to help someone in need in favor of remaining in the security of his home, away from those who might question him or his family. Further, after John O'Keefe's death and after the defense publicly raised a spectator of a German Shepherd attack in open court. We're going to stop here. We're going to go to the court. Okay, where are they getting that court feed? Oh, come on. Now I don't have the feed. Hold on, y'all. I'll find it, guys. I thought I had it. I thought we had a hearing today. Hopefully I'm not wrong, y'all. WCTV, okay. WCTV. I'm looking, guys. I don't know where it is. It's supposed to be today. I think I found it.
Presents itself, but you may schedule a deposition if you need to.
There's no
Thank you, Judge. We also were requesting that because of the discovery issues, that we extend the pretrial motion filing deadline to May the 9th and to presenting the final witness and exhibit list to May the 13th. And the state had no objection to that either.
Ms. Dugan?
No objection.
Those dates then will be moved as requested by the parties.
Thank you, Judge.
Any other matters the defense needs to raise?
Your Honor, we had previously submitted a proposed order concerning the wealth evidence, and we had
Yes.
addressed it by email with your judicial assistant in the state. And Your Honor indicated that we would address it here this morning. The purpose of submitting that is so that there is complete clarity on the court's ruling, that there's not an issue. We are not trying to get into a situation where we're having to seek a mistrial.
As to that, I reviewed the original order and also what was proposed. They didn't exactly coincide. Is there something in particular that you believe needs to be clarified based from the original order?
I don't think that there is. I think that there's a difference in opinion as to what the court's order meant.
I reviewed the transcript on that as well, and I believe as it went to the state presenting any evidence of motive, or specifically that Mrs. Adelson was somehow involved with the offer of money relating to the, I believe, relocation of the children, that evidence would be permitted as far as any general evidence concerning her money, such as what her net worth was on a particular date. That was not going to be presented. But again, as it relates to presenting evidence on motive, that would be presented. What is unclear about this?
I think that clears up the potential confusion, Your Honor.
All right. Ms. Dugan, do you need to be heard on this point?
No, sir.
We've already filed 2 additional motions in limine. There are at least 7 more that we are still working on, and we are hoping to get filed in the next few weeks. When we were here last, I had indicated that there was another motion to suppress. I'd hoped to file previously, but given the depositions that are scheduled, I want to wait until after those, in the middle of April, to get that filed, just to solidify some of the testimony. So that will be filed before the end of April.
Right. As to the motion in limine concerning the use of the book for impeachment, are the parties capable of handling this matter today?
I'm not prepared for that.
We can, I believe that the state's stance is that much of that has already been heard before as well, but we could get with your assistant and set a time for that to be heard.
Go ahead, so that way that matter can be resolved somewhat quickly, I believe, compared to the other motions, but there should be, let's look at the calendar. Probably handle either a 30-minute or 45-minute motion on that. even this week if all parties are capable of handling it. State Defense.
Just looking at my calendar, Your Honor, looks like I'd be available. I could make myself available almost anytime Thursday and anytime Friday.
Ms. Dugan,
That should work. Maybe Thursday afternoon, we could set something. If I could get with Ms. Kappelman and we'll email Lynn this afternoon, would that be okay?
contact Lynn to see what time on Thursday we can go ahead and address the issue
Yes, sir.
Yes, sir.
of the book.
Yes, sir. And then lastly, on the venue issue, we have the materials from our expert. I was hoping to file it last night, but still finishing putting all of the materials together. We also have spoken with the state about their position on filing those materials under seal. That motion to file under seal and proposed order is already done. I can submit those today when I get back to the office. And then the materials themselves, I'd like to say tonight, but realistically, probably tomorrow.
Please file them as soon as you're capable. If there is no dispute from the state concerning whether it's under seal, you may do so.
Ms. Kappelman indicated yesterday that there was no objection from the state, so that portion's already resolved.
Very well. Do the parties need another case management before we get to the more substantive dates and the orders?
The state does not.
Your Honor, at this point, I don't think that we do. If something arises that we cannot work out amongst ourselves and we need to get court intervention, we will certainly contact your judicial assistant.
Well, let me briefly look at the order that was previously set. We're setting all of the dates and deadlines. Looks like the pretrial is already preset by order for 5/16 at 9 o'clock. That will be the next date in which the matter will be addressed outside of any other motions. Unless either party has anything further to address, we'll be in recess for this case.
Yes, sir.
Thank you, Your Honor.
All righty.
That is the conclusion of the hearing. Have a good afternoon, everyone.
I want to double check the date.
Further to address, that will be the next date in which the matter will. Looks like the pretrial is already preset by order for 5/16 at 9 o'clock. That will be the next date in which the matter will be addressed outside of any other motions. Unless either party has anything further to address, we'll be in recess for this case.
Okay.
Yes, sir.
Thank you, Your Honor.
That is the conclusion of the hearing. Have a good afternoon, everyone.
All righty then. That was short, sweet, and simple. That was real easy. Wow. Okay. There we go, y'all. That is all she wrote for Miss Donna Adelson. That was boring. Color it done. Yep. Okay. I expected more from that. I'm a little disappointed. Isn't that horrible? I want more. Give me more. Give me more. I want more. Okay. Well, why don't we just go ahead and keep reading what we were reading? Let me get it back up here. Get it up here for y'all to see. We'll read this and then we'll let it go. And then there we go. And then I'll keep an eye out in Discord if there's anything else that pops up. Let me get this in front of me. Documents. Nothing has come up yet. Okay. Further, after John O'Keefe's death, after the defense publicly raised the Let me enlarge. There we go. Let me get this over. Okay. Of a German Shepherd attack in open court, Brian Albert's German Shepherd was rehomed. It attacked 2 women and their dogs after John O'Keefe's unaliving. Brian Alberts essentially jettisoned a longtime member of his family to another state, out of reach of investigators, out of reach of the defense. The way it looked, any reasonable investigation would have seized the combination of this suspicious conduct in furtherance of a fulsome investigation into the death of John O'Keefe. Brian Higgins, this is how the defense claim that he fits into this circle. Like Brian Albert, Brian Higgins was at the scene of the crime on the night in question. Brian Higgins was at Brian Albert's home at the time John O'Keefe arrived and went into the house. Brian Higgins had been engaged in a flirtation text exchange with Miss Reed in the weeks leading up to January 29th. He testified that Miss Reed had kissed him after he watched an NFL playoff game at her house, game with her and others not long before January 29th. He testified that Miss Reed visited him at his apartment after that. But Higgins acknowledged that the text message, just flirting, and all contact between them ended. And Miss Reed was the one who ended it. She stopped responding to him. She no longer gave him any attention. This was after Higgins indicated in multiple text messages that he was interested in her and found her attractive. John O'Keefe, January 28th, Brian Higgins was confronted with Miss Reed and Mr. O'Keefe walking into the bar together, getting along, and in the words of at least one witness, lovey-dovey. Miss Reed and Mr. O'Keefe were affectionate with each other that night. Brian Higgins was there with Brian Alberts watching it. Higgins' annoyance and irritation was reflected in a sarcastic text he sent to her while she and John were merely feet away from each other. Well, there's evidence that Mr. Higgins wanted to lure Mr. O'Keefe and Mr. Alberts to Mr. Alberts' residence. At the waterfall, minutes before he left, Higgins motioned to O'Keefe, then followed up with a text message to make sure he was going there. Higgins went inside Brian Albert's home. John O'Keefe went inside. There's evidence, therefore, that Higgins had a motive, intent, and opportunity to cause harm to John O'Keefe. Like with Brian Albert, there was also evidence that Higgins' consciousness of guilt. For example, after a long day of drinking and driving, Higgins did not go home after he left the Albertsons' residence that night. Instead, he went to Canton PD station. So he was drinking and driving to the police station. He should have just locked himself in a cell. He initially claimed that he went there to do some administrative work, but later changed his story to going there to move his vehicle. He was consistent, however, about the fact that he never called anyone on the phone while he was there. That turned out to be false. Video evidence undisclosed during the defense during the first trial established that Higgins made a phone call while he was at Canton PD at 1:40 a.m. He has not revealed who he called. Given that evidence was not timely disclosed, the defense did not have an opportunity to confront Higgins about this fact. When Higgins went home after that, he did not go to sleep right away. At 2:12 a.m., he speaks by phone to Brian Albert. He tried to claim the phone reflected a butt dial and apparently a butt answer by Albert's and Higgins' testimony together. The 22-second call, however, is further evidence of consciousness of guilt. When Higgins realized that the defense was interested in seeing the contents of his phone, a defense motion had been filed. He further demonstrated consciousness of guilt by getting rid of said phone and the SIM card. The manner in which he disposed of it, however, was extraordinary, and showed how intent he was on keeping the information from his phone out of the hands of the defense. He destroyed the SIM card, then traveled to the military base and put that tiny object about the size of a thumbnail into a large dumpster. Higgins continued on the night in question and following established clear evidence he should have been investigated during the course of this investigation. But which evidence was ignored by Michael Proctor and his supervisors? Colin Albert, the son to Brian Albert, okay? Okay, Colin Albert has been in a feud with John O'Keefe. Okay. In the weeks and months prior to leading up to January 29th, Colin had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off to his face. Colin Albert testified under oath he had never been in a fight in his life. Yet we have multiple videos of him in fights just before and after the event. But yet there was no video evidence of him taunting others to fight despite desperate for violence. Colin Albert, after John O'Keefe's death, was photographed with his knuckles scraped, consistent with injuries that would have been suffered during a physical altercation. Other videos have come forth since where there are phone recordings of him in fights. Colin Albert's name was purposefully omitted from the police reports. No indication in any of the reports provided to the defense in the first months of investigation that Colin Albert was anywhere near 34 Fairview, his uncle's house, on January 29, 22. In fact, there's no indication in the police report that Colin Albert even existed. It was not until the defense sent a letter to the prosecution while the case was pending before the grand jury, notifying the Commonwealth that Colin Albert should be called as a witness, that the Commonwealth finally produced information that Colin Albert was indeed present at Brian Albert's home the night in question. Yep, it's reasonable inference of the evidence finally and perhaps grudgingly provide to the defense that Colin Albert's name was intentionally omitted from the police reports in order to protect him. Similarly, Brian Albert is the only person listed in the initial report whose first name was not spelled out. He was just listed as B. Albert, and the number to his home is misstated in various first responder reports. These myriad of mistakes are more than simply curious. They are systematic in the investigation. Systemic, excuse me. This appears to be a continuous efforts of the investigators of this case to hide the third-party culprit from the defense and from the public. We've already heard the arguments, so we're going to scooch down because we've heard all of this over and over again. So that is all I wanted to do with this, is to give you what the defense believe is their evidence of Brian Albert, Colin Albert, and Brian Higgins, and why they want them investigated. Okay, we're going to go ahead and end the stream. Thank you so much for joining. If anything pops with Karen Reed in the near future, we'll have back on. Until then, we'll see you later. Tomorrow's my birthday. I will not be live until maybe tomorrow night. If not, for sure, we'll be live Thursday. Nope, Friday. With that, have a great day, great week. We'll see you later. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.